Our top 10 quick list of easily avoidable HIPAA violations includes the following: technology security issues, texting patient information, not getting permissions for messages, misuse of information by employees, social media indiscretion, gossip or social breaches, lack of consent/documentation, medical record practices, lack of training, and not being mindful of in-office communications. Technology and security considerations. Please revisit our cybersecurity information in particular for this piece, but in a nutshell, having secure systems in office for storing and transmitting PHI electronically includes things like encryption, malware, virus protection, access limitations to prevent data breaches. Also, beware of lost or stolen smaller devices that may go back and forth to home and contain PHI, especially doctors' laptops if they're working remotely. Ensure password protection and encryption to access patient-specific information for all personal work devices. A few common examples of things that have gotten people in trouble include sharing computer usernames or passwords, leaving a computer unattended, which allows someone else to access or view sensitive information, whether at work or if you are using a laptop from home, and failing to encrypt portable devices that in turn allows access to patient information. Texting patient information. It might seem like a fast and efficient way to communicate, but it can put PHI in the hands of cyber criminals. Encryption programs can allow confidential information to text safely, but the office and the patient both must have it installed on the wireless device being used. In general, texting patient information is not a good idea. Permissions for messages. Unauthorized release of information to family members or third parties is another very common HIPAA offense. Has a patient told you that you can leave messages about their care, appointments, diagnosis, test results on an answering machine, for example? Please get that authorization in writing. If you don't, get the permission so that you don't end up leaving a personal message with information on a household answering machine where family or roommates can access it. Also, confirm with the patient exactly what numbers are okay for messages. Just the cell phone, work phone, home phone, etc. All employees can put a provider office at risk. As a matter of fact, snooping on healthcare records of family, friends, neighbors, coworkers, and celebrities is one of the most common HIPAA violations committed by employees. Accessing patient files when not authorized, outside of the realm of business practice, whether it's curiosity, spite, favor to a friend or relative, accessing and sharing this information is illegal and can cost a practice substantially. Only the people named, the actual individual patient, the power of attorney or named representative that the patient puts on record, can ask or access patient information. Some of these violations include accessing information that employees don't need to know to do their job, sharing sensitive information with unauthorized individuals, copying sensitive information without permission, and discussing sensitive information with unauthorized individuals. And a friendly reminder, when you violate HIPAA, you aren't just getting the doctor or the office in trouble. The individual violations will be faced by the individual person or persons involved. Social media indiscretion. We've talked about this a lot in this course. This is discussing work or patients on social media, posting pictures of patients on social media, naming names or other identifiers of patients on social media. The use of social media for any sharing of patient information is a HIPAA violation. Gossip and social breaches. This also goes along with accessing non-authorized information. Whether accidental or intentional, this is a common mistake and cause for HIPAA violation. In small, close-knit rural areas, it can present a bigger problem. People all know each other and are used to casual discourse about other community members. Don't do it. Whether to friends, family, unnecessary coworkers, or just being loud in the office where other patients can hear what you are saying, gossip and social breaches are a violation of HIPAA. Lack of consent or documentation. Have signed privacy policies for new patients and do this before any care is ever administered. Note, there are typically a couple of signature slots on privacy forms. Patients must initial that they received it. They must also sign if they agree to the policy and how information may be used. If they don't want to sign that piece, that's okay. But it means that sharing of most information needs their consent in a separate form. In general, HIPAA protects patients, so not signing is a bit silly. Also, there are a variety of exceptions where doctors must share by law info and patient information that authorization would not be needed for. Patients that refuse to sign for whatever reason will be a rare scenario in the office, but it could occur. Also, we repeat here. Are there family members or powers of attorney that can access records? That needs to be put in paperwork signed off by patients. Can you leave messages on a machine? If so, which one? And have that permission in the records. The rule of thumb is document everything. Medical record practices is another huge area of issue, whether paper or electronic. Stored files must be secure. Encrypted and secure server for electronic, and a locked room inaccessible to non-essential workers for printed records. In-office systems should also look at filing protocols. Back in the day, we'd use last name, first name, and anyone walking by a treatment room could peek at the name on the file sitting in the holder outside the room and know who's in there. Today, consider having a number that correlates with the patient, or only using the first 3 letters of a patient's last name on the outside of a file. For sign-in sheets and calling patients back to a treatment room, instruct that only first name and last initial be given. Look at safeguards for files that are not in the file room. That means they're in the hallway, they're in front of a room, or they're in a room. What if one is left in a room where anyone else that enters can see it? What systems does your office have in place to ensure that vital information gets transferred out of an insecure location back to a secure location? Medical records practices also includes improper disposal of medical records. Records should be kept at least 7 years from the last patient visit. And when disposal is needed for those records or other paperwork for scheduling or billing, those should not just go in the trash. They must be properly shredded and then securely disposed of, and there are services that can provide this. Lack of training. Ignorance is not bliss. This is very straightforward. Lack of training or knowledge about HIPAA is a primary part of office violations. Whether employees lack training and familiarity with HIPAA regulations or the employer did not ensure training for their office staff, it puts the office at a huge risk. Perhaps it even includes a lack of policies and procedures, and or a lack of privacy policies, or a lack of in-office systems or electronic security systems being in place. Ensure training is happening for every individual in the office, especially new hires. to avoid this common cause of noncompliance. Office communications. Even with coworkers, communications must be private. Discussing sensitive information in an area where others might overhear the conversation is a violation of HIPAA. Are offices private? Is scheduling private? Billing, where names, conditions, or circumstances may be overheard? Remember our example of an intern at a Big Ten university hospital system where an elite athlete's pregnancy status was discussed between colleagues but breached because of other patients in the office that overheard them. It resulted in violations, fines, and loss of employment for the intern, not to mention the pain and suffering of the patient whose privacy was violated. Also remember, if a breach does occur via communication or cybersecurity, you must issue notifications of breaches without unnecessary delay and no later than 60 days. A delay in reporting can become a violation itself.